time now for another In the Legal Know with Vincent J. Russo, who is joining us here in the studio again. And today, fourth part of your final series on trusts and Medicaid, Vincent.
Yes, great to be here again.
Love having you here.
Thank you. So this is the fourth part. So let's just talk a little about what we've covered. So in the first two parts, we focused on seniors and Medicaid, such an important benefit for seniors who need long-term care. And in regard to accessing Medicaid, you need to protect your assets by placing them into a Medicaid Asset Protection Trust. And you can also protect your income by placing it into a pooled income trust. So these are two very important trusts for seniors, and planning in advance is critical. Mm-hmm. The third part, we then focused on younger people, people under 65, who are disabled. Here again, it's so important they access government benefits. So the important trust here for that individual is a first-party special needs trust. So if that individual has assets in their own name, it disqualifies them for Medicaid. They can place those assets into a first-party special needs trust and immediately access Medicaid. So a terrific benefit. Now we get to the fourth part, parents. Parents who have a child, minor or adult, with special needs. How do they protect that child and make sure they're maximizing their government benefits? So we're talking about a third-party supplemental needs trust, sometimes referred to as a third-party special needs trust.
Okay.
But I like the term supplemental needs because that's what the trust is all about.
Yeah, of course, this is, parents are so worried about their children. When and how would you do this trust?
Yeah, and I think the worry part is really critical to focus in on because parents who have a child with special needs, in the back of their mind, they're saying, oh my goodness, what if I'm not here to take care of my child? How do I leave assets in a most protective way for that child? So that's where the third-party supplemental needs trust comes in. That should be done immediately in terms of planning because, no one knows when the day will come where someone becomes incapacitated or passes away.
When you say immediately, if you have a child who's born with special needs, you mean immediately?
Yes,
you do it then?
I think it's immediate. And it's so hard because there's so many things going on for those parents at that time. I've been through it personally. And but you have to kind of look at the big picture as best you can and implement estate planning. And this is the most important vehicle for the parents. So the parents can leave those assets and get the benefits of the child maximizing government benefits, asset management of those assets, and then using the income and the assets to protect those, to protect that child. So here's a good, I think, summary here of a third-party supplemental needs trust. It's set up by the parents under a will, or it can be done while they're alive in a living trust. It's funded with the parents' assets for the benefit of the child with special needs. There's a lot of flexibility in how the funds are utilized. And the last piece, the child continues to receive government benefits, Medicaid and supplemental security income.
Okay, so how does a parent do this?
Okay, so how they do it would be to get the advice of an elder law or special needs attorney in particular, estate planning attorney in general, and discuss the concerns they have, review the assets that are involved, and then come up with a plan. So the plan would be, if it's under a will, and that's most typical.
Okay.
So the parents would sign a will. Let me give you an example. Maybe that's the best way to do it. Let's say the parents have two children, John and Mary has special needs. So the first question we're going to ask is, how much do you want to leave for John, and how much do you want to leave for Mary? Sometimes the parents say, I want to leave it all for Mary, because that's where our biggest concern is. Some parents will say, I'll leave it 50-50. So let's say we left it 50-50. So the will is going to say that when the parent passes away, the half of the assets they have will go into a trust under the will. So document, the will itself will say what that trust provides for. And the assets will go into that trust. A trustee will be named. And then the trustee will manage those assets and use it for Mary for the rest of her lifetime. While, again, accessing government benefits.
Okay.
That's the key.
Extremely important, as you just said, you really need professional advice on this one because
Yes.
it's so complicated.
Yeah.
Okay.
Yeah, I just don't, you can't do this on your own.
No, absolutely.
And the government benefit programs are so complicated. You know, I'd love to come back again and we'll talk maybe about just how SSI works.
Okay.
It's a very complicated program. And so getting the right advice is really critical. Sometimes parents will look for the easy solution, but the easy solution may not be the best solution. And what I mean by that is, well, why don't I just leave all the assets to John? And John will take care of Mary. But bad things could happen to John, undue influences, creditor problems. John could pass away. We don't know what's going to happen to the assets. So the better route is to put it into a trust, have a family member or professional be the trustee or co-trustee, and protect those assets.
Okay. Third-party trust, extremely important. Get advice on it because it is not easy.
Yeah.
And we appreciate, obviously, you always coming in. And we will see you next month.
Yes. See you then.